Hello, and welcome to the inaugural edition of Williams Mullen's Trending Now, an IP podcast. It's a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Clint Brannon, and today I'll be joined by my colleague Tom Bergert, a partner in our intellectual property practice group here at Williams Mullen, to discuss the timing of patents. How are you doing today, Tom?
Doing great, Clint. Great to be here. How are you?
I'm doing pretty good. So the timing of patents, Tom, we're now in 2020, and the U.S. Patent Office has issued over 10 million patents. From a sheer numbers perspective, what are we likely to see in the coming decade?
It's a great question, and you're right. We hit 10 million patents back in June of 2018. We're already more than halfway to 11 million, and so that's a year and a half and change from when we hit 10 million. And to put that in perspective, we didn't hit 1 million patents in the U.S. until 75 years after the first patent was granted. So the rate of patents being issued is increasing, and the rate of patent applications is also increasing, the filings. So I think we're only going to continue to see that increase.
And why is that, Tom? What factors are contributing to this?
A lot of them. I think you have many more technology areas. Our iPads and iPhones have only been around for a short period of time. Wireless technology continues to improve. You got genetic engineering, cybersecurity, things that didn't really have viable patent opportunities or weren't even around for a long period of time. And so there's more technology, there's more competition, there's more awareness with digital records of the Patent Office filings. Global companies can participate and see who's filing what. And with all of that and all of the opportunists out there seeking patent protection or trying to acquire patents, there's more volume.
That makes a lot of sense. What are some of the important timing factors that people need to be aware of when they're considering patents?
Yeah, so with all of the noise, if you will, of the volume of patent application filings, it's important to keep perspective. Things don't move as quickly as, let's say, society does in the patent field. So patent term is something to keep in mind. Patent pendency and the patent filing rules all have implications with regard to timing.
And could you just explain briefly what patent term is?
Sure. So in the U.S., generally speaking, you have plant patents, utility patents, and design patents. The primary ones that we're familiar with are utility patents that protects the function of an idea. The design protects how it looks. Utility patents are granted for 20 years from the filing date of the application, as long as they're maintained over time. Design patents are granted for 15 years as long as the application was filed after May of 2015.
So how long, once I file my patent application, how long can I expect it to take before I actually get a patent in my hands?
So that's a great question. So patent pendency really depends upon the technology area, what the backlog is at the U.S. Patent Office, what type of application, is it a design, is it a utility, and also how aggressively the applicant seeks to pursue patent protection. And oftentimes with prosecution, you can get an early positive response, and sometimes it can take much longer or you may not get that at all. And so that does bear on how long it takes to get the patent.
What are some recent trends in patent pendency looking like?
I practice in this field and I've seen it, and the statistics seem to bear it out, that the patent application pendency, at least from the date of filing until your first office action on the merits, has reduced. It's down to just under 16 months according to the U.S. Patent Office website. And the average overall pendency time is down to about 2 years, just under 2 years. Again, many factors can influence whether that's going to be shorter or longer.
Are there any exceptions to sort of the standard timeline?
There are, right. You can have different situations where you request accelerated examination, for example. You may have situations where you received an allowance in a corresponding application abroad, and you can accelerate the examination based upon that. So there are exceptions. You can also have cases where it takes 5, 6, 7 years at times because you need to file continuations or otherwise prolong the prosecution process.
And what can someone do as a patent applicant to expedite that examination process?
So one thing I was asked one time is, can you just say that your invention is really, really important? And that's not something that you're allowed to do. I think most applicants, if not all applicants, think that their invention is really, really important. You can't ask for a favor. You can't go to the examiner and say, just do me a solid this time and I'll get you back next time. Some of those things, believe it or not, people have asked if you can do to expedite your application, and that's not true. You can petition to make your application special based on the applicant's age or health, for example. or based on the topic, if the application relates to countering terrorism, for example. There are also ways to prioritize examination based upon paying more money. There's something called the Track 1 prioritized examination process. Currently, the USPTO limits that to $12,000 per year. And coincidentally, it seems like we're on pace, according to the U.S. Patent Office, for about 1,000 of those requests per month. So they're right in line with what the current number of requests for prioritized examination are.
Are there some other ways that an applicant can get a more speedy patent issued?
There are. I mentioned it earlier. If you're receiving corresponding application allowances in, let's say, a foreign application in Europe or Australia or somewhere, and you wish to try to match your U.S. claims to what you've experienced in allowance in another jurisdiction, you can request what's called a patent prosecution highway, file a patent prosecution highway request, which then can, if it's accepted, can put your application out of turn so that you get examined sooner.
Let's talk a little bit about some of the rules that go with patent filings for a few minutes. What rules do we need to keep in mind, and how do they affect the timing of the patent process?
A great question. So sometimes we hear, well, I just want to sit on my invention for a while and maybe file for protection in a few years, and maybe that can prolong the life of my exclusivity rights. And that's not true. You can't do that. In some cases, if your invention is not made public, or you've kept it under only disclosures where there's a non-disclosure agreement in place, an NDA, then you can delay your entrance into filing the application. But most countries operate under what's called an absolute novelty standard. So if you file your application before any public disclosure or display at a trade show, for example, that can preserve your rights to pursue the patent protection. The U.S., Canada, and some other countries give you a one-year grace period, but that is a very nuanced type of analysis, and for anybody considering taking advantage of that, it's very wise to seek informed patent counsel on that type of a question. Yeah, with timing of your patent application filing, Clint, most countries operate under what's called an absolute novelty standard, which means you need to file your application before any public disclosure or sale or offer for sale of your invention. The U.S. and Canada and some other countries will give you a grace period. In the U.S., it's 1 year, but those types of activities are something that you should consult with appropriate patent counsel on before you engage in them. It's a good bet to file before any public disclosure if you can. That does preserve your rights to file domestically and internationally. Also, having NDAs in place, non-disclosure agreements, is a good idea for any disclosure that might otherwise prohibit you from filing a patent application.
Could you give the audience some ideas of what kinds of activities might constitute a public disclosure, just so they know what to look out for?
Sure. So this can be something that, again, is not under an NDA. Maybe you have an investor proposal, you're trying to get investment in your invention, or you're going to a trade show and you're trying to generate sales, or you're making phone calls to prospective clients about what your idea is. Those types of things can be potential disclosures that then ultimately prohibit you, or at least limit you, in obtaining patent protection. We could probably have a nice 30-minute dialogue for the half dozen listeners right now, if they wanted to hear about more details on this. But I think when you're talking about the types of disclosures, if it's of the whole invention that you might seek patent protection on, that you're actually claiming, that's the worst case scenario. If you, say, have concepts A, B, and C in your invention and you disclose concept A, that doesn't mean that's going to prohibit you from seeking protection for A plus B plus C. So it's just very important to keep that in mind. And again, for any type of international prosecution effort that you might have, the best rule is really file first before any kind of disclosure.
And so it sounds like it's in an inventor's best interest to get an application on file as soon as possible. But what if they're in a situation where the invention is not really fully developed yet? How does that impact the patent application process?
Several ways. And so one thing to think about is a provisional application. It's an application form that doesn't get examined, but it gives you 12 months in which to convert it to the creatively named non-provisional application. The provisional does not need to have claims, and so it's not exactly the same requirements. It's usually much less expensive to file. The challenge with that is, as your invention is developing, it's not a set it and forget it type of application. You want to maintain attention to it over time so that you can update it, possibly file one or more provisionals in the interim between the first filing and the deadline to convert.
And what are some of the advantages of provisionals?
Again, the cost savings is good. It's not the same expense. It also gives you time to seek funding or test out the invention or complete the development or do searching if you're interested in learning about the prior art without bearing the full expense of the non-provisional.
All right, well, that's all very helpful, and I think that helps us understand the process and some of the pros and cons of different approaches. What are some of the thought takeaways that people need to keep in mind with regards to patents and timing issues?
First of all, I would say it's important to put patents in perspective. Like we talked about, it's 20 years of rights in exchange for disclosing your invention to the public. It may take 2 or 3 years to get the patent, so those that have the ability to foresee what might occur in 2 or 3 years as opposed to 1 year or 10 years, some standard timelines we're used to thinking in, I think you can be at an advantage at the patent office with the process. It's not something that issues overnight. It's not sort of an instant type of gratification situation. So I think with patents, if you can put them in perspective and the amount of time that you get for them, that's one thing to think about. It's not a set it and forget it type of asset. These are assets. These are investments that you make. So you want to invest in a quality application with your house or with your car. You're always maintaining those types of assets, and with patents, you should be maintaining them too, especially given the timeframes that are involved.
Thank you, Tom. I think that'll wrap up our discussion about the timing of patents. I'd like to thank Tom Bergert for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. And there you can find out more about our team as well as past episodes of podcasts and legal alerts. Please be sure to subscribe to this podcast to be notified when our next episode posts. Thank you for listening, and until next time.